Hi, start with an apology. The file, the presentation is corrupt, not me, it's the file, okay? So basically we'll just talk through welfare benefit appeals. It's very specific. My name is Vaughan Thomas. I work for Norfolk Community Law Service. It's a Norfolk-wide organisation, a small local charity, and we specialise, the area that I work in is the Welfare Rights and Representation Service. Basically, we act as advocates for social security tribunals. In order to be a client of ours, you need to sign up and sign a letter of authority. We can't act for anyone unless we've got their authority to do that. Norfolk Community Law Service specialises in social welfare law. There are other areas as well as welfare benefits. I only deal with welfare benefits. There's debt, housing, domestic abuse, various areas. We don't get involved in criminal law, but having said that, we have about 40 solicitors who offer a pro bono service, initial advice. So really we cover everything in one way or another. And if we don't cover it, we can signpost or refer you to an organisation that can. Norfolk Community Law Service is also part of Norfolk Community Advice Network. And this stretches right across Norfolk, of all the other advice agencies and support agencies and local authorities across Norfolk. The not-for-profit charitable sector is very collegiate. We don't compete against one another. We don't get very precious about our clients. If it's another organisation is better equipped to deal with them or a different specialism, we refer on. And just as other organisations refer to us, because of our specialism in welfare rights and representation, we don't do what the citizens' advice would do, would help with initial claims, filling in forms. So it's when things have got to a point where there's a tribunal coming up, basically. And so we have advocates, not just myself, there's several others, other caseworkers who get involved. The network, and the idea is basically just one point to sign up to. So you don't have got to regurgitate all the information and the issues to different organisations as you get referred. The initial issue is whether you can appeal or not. Before you can go to an appeal, a hearing before a tribunal, a judge, you need to carry out a mandatory reconsideration request. There's a sound logic to this. The best tribunals that you can have are those you can avoid. We'd all go for that. I mean, quite frankly, I shouldn't have a job. You should be getting the correct decisions in the first place. But you know, it's always been the case that you could ask for a review before an appeal anyway. But the idea is to avoid that tribunal, or for the DWP, the different departments, whether it's personal independence, payments or universal credit, to see whether they've made a mistake. It's quite possible. I only see mistakes, I only see problems, quite frankly. But it's good that they could take it and look at it again. So you make the request, you have an automatic right to make a request within a month of a decision. You can submit a late request after that. The later the request, the better the reason why it is, if you've been in hospital or there's been a postal strike or something like that. But it's quite frankly fairly futile just asking to look at the decision again. Although to be fair to the DWP, they'll take that decision and it'll get passed to another decision maker. It'll be a fresh set of eyes, so that's really good. They'll give it another look and say, well, have we made the right decision? But what's really required is to treat that mandatory reconsideration request as if it's an appeal. It's about getting more evidence. The decisions are made on evidence. Unfortunately, the decision maker will have never met the person who's making the request. The process of making a claim, whether it's a disability, and it doesn't necessarily have to be a disability, we deal with all the benefits right across the board. The vast majority of the benefits that we deal with are personal independence payments, universal credit, used to be employment support allowance, used to be incapacity benefit. They keep changing. We keep having reforms, in inverted commas, changes to the system. So basically it's about making sure you get that further evidence. And that further evidence can be a letter from the GP, a copy of the medical records. It could be from a social worker, for an occupational therapist, psychiatrist, psychiatric nurse, anyone. School, which the previous talk from the Senko. We're dealing with a civil issue. When you get to a tribunal, it is a judicial hearing. You know, but before we get there, if you can get it changed, we want to get it changed. Quite frankly, even though my job is about going to tribunals, yeah, I'd love to not go to tribunals and get the right decision in the first place. So it's about getting that further evidence, and with it being civil, not criminal, and I have to say the vast majority of the people I represent think in terms of criminal. It's either innocent or guilty. It isn't. It's about making sure that we get the right decision. And on the civil cases, it's inquisitorial, not adversarial, which is to say, when it gets to a tribunal, the tribunal will just keep asking questions and drilling down until they feel they've got enough information to make a decision. I know clients feel as though it's innocent or guilty. It certainly isn't. But one of the benefits of it being a civil issue, we can say, well, what we're looking for are, say, the maximum award, and then, if not that, then a lower award. It's like an alternative or a fallback position. Well, invariably, when they get to me, they've obviously the mandatory reconsideration as not being successful, or not as successful. It might be they've increased an award, but still the client doesn't feel it reflects the level of disability or incapacity of that they've got, which is fine. We take instructions. We don't give instructions to our clients. Our clients tell us what they want, and basically we act as advocates for them. The idea is to put the advice agency between the client and the problem, to give a voice, to act as an advocate. We're not there as mediators between the client and the DWP. So in that initial fact-finding, evidence-gathering process, and it can be quite involved, and I have to say our success rate when it gets to tribunal is not due to highfalutin legal argument, really. I do try highfalutin legal argument. I'm not a lawyer. I'm not a medical professional. I have on a number of occasions used the Human Rights Act because, quite frankly, all the people that I see and represent, they want one thing, social justice. But all we can go by are the regulations, the legislation, the guidelines. And it has to be said, sometimes the law is an ass, or appears to be an ass. And so we need to be able to challenge that sometimes. And thank goodness we've got the Human Rights Act, and we can do that. It's a bit like a nuclear option, really, because if you were to win on the Human Rights Act, it wouldn't be just you, it would be thousands of other people. So the DWP then starts to gather forces, legal advice, solicitors, barristers against that argument. But if we move on from the mandatory reconsideration, and you have to have a decision at the mandatory reconsideration, we have to have a notice from that before you're allowed to go to tribunal. And again, you have a mandatory, an automatic right of appeal within a month of that decision. And again, if it's outside that period, and there's an absolute time limit of 13 months, you basically need a good reason why it's delayed. And I have to say, over the last couple of years, unsurprisingly, there's been a pandemic. Yeah, very good reasons. Our offices shut down. All staff were working from home. We started working remotely. And I have to say, yeah, Her Majesty's, and it was Her Majesty's then, Courts and Tribunal Service, started having remote hearings, which were over the telephone or video, more just telephone. I was very sceptical. I really believe passionately there's no substitute for meeting people. There are things that pass between people you don't verbalise, let alone write down. So I was sceptical whether it would be successful. But we started having tribunals remotely over the telephone. And we are a Norfolk-wide organisation. And it can be quite problematic for people to get to Norwich. You used to have hearings before the pandemic in Norwich or King's Lynn. I have to say, they were successful. Now, our success rate didn't go down. And quite frankly, for clients who are suffering from mental health issues, panic attacks, depression, they're sat at home, sat on a settee, on a telephone, rather than going to a venue, sat in front of a judge and a panel, which can be quite nerve-wracking. And they are meant to be informal. It's civil. And the idea is you don't need representation. Don't believe that for a minute. You need representation. Having a representative is a bit like insurance. No one's really interested until you need it. And when you need it, you haven't got enough of it. We're doing tribunals every week. So obviously it's about familiarity. I've been doing welfare benefits tribunals for over 22 years now. As I say, I'm not a lawyer, I'm not a medical professional, but it's about gathering that further evidence. And the success rate, it used to be about 70%, it's over 80%, which in one sense you think it's fantastic. And yeah, people say, oh, it's really good. Yeah, well, yeah, I suppose it does. But really it's not, it's appalling. Because these are decisions, DWP decisions, which were wrong. And the decisions are overturned, and then the decision is backdated, and the time lag between a decision, a negative decision, and a mandatory reconsideration notice and getting to appeal, it can be several months if you're lucky. It can be a year plus, it could be nearly 18 months. And when you get to tribunal, it's not about the date of the tribunal in terms of assessing whether you qualify, it's what you were like on that day when that decision was made. So it's not how are you, it's how were you. And that can be incredibly problematic, quite frankly. Just think back of the problems you had getting upstairs, in and out of bed, in and out of the bath, on and off the toilet, whether you could cook food, and the minute detail of how you went about things. But that's the way it is. If there's a change in your circumstances between the decision and the hearing, that's not something that a tribunal can take into account. And if your conditions got better or got worse, you need to notify the DWP. And that will be a fresh decision. So the original decision that would be under appeal, if it was successful, it would be up to the date of that new decision. That can be not a very attractive prospect, but that's the way it is. And quite frankly, if you didn't agree with that second decision, if your conditions got worse, then you'd have to go through the same process again, asking for a mandatory reconsideration. And again, it is about gathering that further evidence. But of course, the best evidence is the appellant themselves, the person who's making the appeal. As I say, there's no substitute for that person, albeit now it's over the telephone. And I have to say, the remote hearings which we were forced to have, and all credit to His Majesty's now, His Majesty's Courts and Tribunal Service, they've retained that option. Really pleased. That shows the adaptability. And some of the changes that we've had, I think, quite frankly, over the last couple of years, it would have taken 5 to 10 years to implement it from the Ministry of Justice's point of view. But we've done it, and it's been successful, and I think it's really good. It's a good that people have got that option. But it's about being able to talk to the appellant themselves, to clarify it, so they can put their position at the appeal. As a representative, I couldn't answer questions for an appellant. They have to answer it. It's normal conversation. It's not about making a presentation. It's not about memorising the bundle. This is a bundle of papers, evidence that the DWP put together. This can run into hundreds and hundreds of pages. But we need that because the tribunal can refer to specific things. There are copies of the claim forms in there and the assessments. And of course, most people, certainly for PAPER and for universal credit, if they were looking at disabilities and incapacity, will have been assessed. Most recently, almost certainly, it would have been assessed over the telephone again. And I go back to, there's no substitute for meeting people, and that hasn't been the case. And people have a sense of unfairness and not having a thorough assessment when it's only been over a telephone for a matter of, 40 minutes, when their entire life is being assessed. So I understand that, but the person that makes the assessment isn't the decision maker. There's no point in having to go at the person who's making the assessment. They're trained in disability issues. But having said that, the assessor could be a nurse, could be a physiotherapist, always used to be a doctor in the old BAMS, the Benefit Agency Medical Services, but now it's not. It could be a psychiatric nurse, But then if it's someone who's got a bad back, you'll be thinking, well, wait a minute, it's a bad back and I've got a psychiatric nurse assessing me. They have this sense of unfairness, and you don't need a law degree to feel it's not fair, really. So that's why people take things forward. And it's about, well, our guarantee is that we help to make sure that people are treated fairly, justly. That's what it's about. We can't guarantee a particular outcome, but having said that, if we didn't think there was a just case, we wouldn't take a case on to represent. But that's why we end up at tribunals. And again, the tribunal get to see the appellant face to face, ideally now, unless it's still over the telephone. The decision maker never got to meet the appellant. That's a huge shortcoming, really, and that's why I feel that we get the decisions we get. And I have to say, it's not just me, but the people I represent feel the system's crumbling. And yes, the number of mistakes, the misunderstandings, miscommunications. But then I went to a disability conference a few years ago, and there was the head of the medical services for the benefits agency, as was, and I didn't recognise what she was describing, and I waylaid her at lunchtime. I said, well, no, this is completely, your organisation is just way below acceptability. And she said, no, we send out 26,000 surveys a year, and they come back very positive. And it made me think, well, yes, I only see negatives. People only phone me when they've got a problem. They don't phone me when they get the benefit, of course, yeah, so yeah, okay. Mine's a skewed view of the system. So successful people don't come to see me. But having said that, as a welfare rights worker, it's about making sure everybody's getting a fair crack of the whip and getting a fair assessment and treated justly. And of course, there is the appeals, the mandatory reconsideration process, then the appeals process, but don't confuse those with the complaints process. It's a separate issue altogether. You can complain as well as appeal. A complaint could be that people aren't, or the DWP are not responding to your letters. There's a delay. You're not treated appropriately, you're treated rudely, which can amount to maladministration. That's a completely separate thing. It doesn't reflect or have an impact on the appeals process. And I have to say, I don't go down the complaints procedure nearly enough. Quite a few of the appeals that I deal with, there could be complaints, but we're just full on just doing the appeals. Having said that, I do sometimes when I get particularly, how can I put a word? Yeah, cross at the way some of my clients have been treated. One I remember was a chap with learning difficulties, kept running into the sand with the job centre again and again, and I'd tell them, learning difficulties, you need to make those reasonable adjustments. But they didn't. They kept again and again getting decisions, the wrong decisions, because basically they weren't taking into account his disability. So we did. We went through the complaints procedure as well as the appeal procedure, and we exhausted the internal complaints procedure. And so then we went to the Ombudsman. And in order to go to the Ombudsman, you need to get a form signed by your MP. So we went through that process with the Ombudsman, and the Ombudsman came back and said, yes, there should have been reasonable adjustments for your client. And he awarded the client £1,500 compensation. That was separate from the appeal, which we still went ahead with, and I'm pleased to say we won. But all the cases are different. People's circumstances are different. But in terms of the disabilities for personal independence payment or universal credit, it's assessed points-based. And for PIP, well, personal independence payment, you need at least 8 points for a standard award, 12 points for enhanced award or higher. But of course, when you fill the forms in, there are no points there. It doesn't tell you about the points. It just asks you questions about your ability, how it affects you, the impact on it. It's a bit like being invited to play Monopoly and not being told what the rules are. Of course, you still have to answer appropriately if you have certain disabilities, but what they're looking at are the disabling effects of your condition. And it's very helpful to get copies of medical records, medical reports. We're a small charity, we can't pay for medical reports, but clients, patients have a right to their medical records. Very good. Excellent evidence. It's neutral. It's not written with an alternative agenda in mind. It's not written in order for patients to get benefit. It's just a record of a diagnosis, prognosis, record of treatment. And of course, all these things, how these things impact on a client, a patient, including the medication. I see people who've got physical issues, incapacities, disabilities, and then they have mental health issues because they get depressed about the things that they're having to experience. And then they're on medication, and then they start getting side effects from medication. And all these things, how they all add up, and the impact it has on a person, it's unique. And what we need to get across is that uniqueness of the client, the patient, in terms of the disabling effects. When we get to tribunal, and now we're now going back to having face-to-face tribunals, you'll get a decision on the day. They allow about 40 minutes, but quite frankly, it could be a lot less than that. I've been in tribunals that have gone for a couple of minutes. A couple of minutes, that's 120 seconds. Because basically the amount of evidence that we've got and submitted, the panel, which will be made up, if it's for a personal independence payment, will be a judge, a doctor, and a disability member who might be disabled themselves or have additional insight and understanding and hopefully empathy with regard to disabling effects of conditions. That decision, they'll have read all the paperwork, they'll have read through the bundle, and if it's so overwhelming, then yeah, they just need to quickly go in and see. They are judicial hearings, so the DWP can and do send a presenting officer. The presenting officer technically is there to aid the tribunal on points of law, which is interesting. I've yet, over 22 years, not seen a presenting officer pick up a judge on points of law. Judges are quite knowledgeable about the points of law, but they're entitled to, which is fine. Sometimes it can go on a lot longer. I've been in tribunals that have lasted a couple of days. Usually it's to do with fraud, and then we'll have to plough through videos. I recall one case, there were something like 6 investigators, which I found quite astounding, really. This is something you might reserve for drug lords. And certainly we weren't at that level. But again, it's about making sure all the evidence is presented and that the tribunal get to look at it, and everyone from the DWP as well as the client and the people from Norfolk Community Law Service get to review it. Of course, we don't always agree with the decisions we get at tribunals. Sometimes, and we all look at the same evidence, but we don't come to the same conclusion. And that leaves me all quizzical. I'm thinking, how can that be? I think they should have been awarded a benefit, a certain level of benefit, but they're not. But if we think it's not right, we can ask for a statement of reasons. Again, the tribunal, the judge, has to justify why they've come up with the decision they have. So asking for a statement of reasons, which you can request within a month of the decision, and they go through it, and we can look at the possibility of taking it further to the upper tribunal. And the upper tribunal, or used to be called commissioners, it would be an argument on a point of law. The process was wrong. Something wasn't quite right. I mean, there's no medical examination in a personal independence payment. So if there was a medical examination, that would be an error in law. If we got into the tribunal venue room and the presenting officer was already in there having a chat with the panel, that would be an error in law too, because no, you need to enter that room together to be fair, to make sure we've got equal access to the panel. We are successful in that sometimes. I recall usually the success at the upper tribunal means a reconstituted tribunal, first tier tribunal again. Another bite of the cherry, quite frankly, so the process can be done correctly. There was one case, was basically a client for a child with Down syndrome, and we were asking for a high rate mobility of DLA. DLA still exists for children, that hasn't gone by the wayside. We got to tribunal and we failed. I couldn't understand it. Basically, a child with Down syndrome, and as a small child, she'd throw herself on the floor, mum would pick her up, no problem, get on with life. But by the time the child had got to about 11, she couldn't do it anymore. She couldn't pick the child up, couldn't manage, needed to get the high rate of mobility. But you can only get the high rate of mobility for DLA due to a physical disability. And we were turned down. I just bamboozled myself. I mean, I'm not a doctor, I'm not a lawyer. I started checking the facts and I said, well, it's chromosomes, it's to do with chromosomes. It is physical, to do with Down syndrome. And so we applied to the commissioners, and eventually we got a response from commissioners. They agreed, said yes. And they, first time I've ever known it, and the only time in 22 years I've had it, the commissioner substituted his decision for the tribunal's decision, instead of asking for a reconstituted first-tier tribunal, and we won. Unfortunately, the mum had had nearly 2 years of struggles and basically heading for a breakdown, trying to cope. But we eventually won. The overarching sentiment for welfare rights is persistence. If you feel it's not quite right, get advice. Don't automatically accept what you're being presented with. Welfare rights, social welfare law is complex. Always get a second opinion. There are enough advice agencies out there, and the Norfolk Community Law Service, that's about as far as the display goes, there are leaflets outside. Any number of advice agencies who, if they can't give you direct information, they can refer you, signpost you, and local authorities as well, including county council. And it could be a decision to do with housing benefits, say, in which case the local authority could hardly represent themselves against themselves, so they need independent, and that's the crucial thing. We offer independent, impartial, confidential advice and free representation. It used to be that we were funded by legal aid. Many of the posts I've had in the Midlands and London and in East Anglia were funded by legal aid, and then the government decided to abolish welfare benefits for legal aid. Also, I don't agree with that, but we're not going to get political. It's about getting that further evidence. One of the great things about legal aid was we could get disbursements for further evidence to pay for medical reports. We can't do that now. Hence, going down the route of asking for a copy of medical records. All you're asking for is a copy of the medical record, and of course in there you will have reports from specialists, consultants, hospitals. Although we're just talking about photocopying, we are asking for that and making that request under the Data Protection Act. Doctors' surgeries have up to 40 days to respond. Our specialism is advocacy at tribunals, and sometimes it's just a matter of a few weeks before a tribunal is being listed. It's very difficult to get hold of that. We can ask for postponements and adjournments, but it's about getting that further evidence and knowing where you can go and get it. It's already out there, and technically speaking, the DWP could do the same, but we live in the real world. We know that they're dealing with thousands of cases. The decision maker, when the decision maker feels they've got enough information to make a decision, they can. And sometimes it's quite puzzling why they've made a decision or not sought some further evidence when it was plainly already there. But then that's why we go to the independent sector. It's really, really important. The not-for-profit charitable advice sector and support sector is not icing on the cake of the community. It's part of the community. And quite frankly, it's saving government, local authorities, millions. And as a welfare rights worker, I couldn't not mention the people who do not claim benefit and should. They qualify. And for Norwich itself, the last time I looked, there's about £11 million a year, every year, of unclaimed benefit. Put those claims in. Nationally, it's about £16 billion of unclaimed benefit. This is a phenomenal figure. This is what people are entitled to. We're going through a cost of living crisis. It's a simple thing. We should be claiming that, getting those claims in. It's complicated. Some people don't want to. Well, you don't have to. Or if you don't want it, that's fine. Then don't claim it and pay, give it to a charity. That's basically, it's making sure that everybody's getting what they're entitled to. It's not rocket science. It's not about people getting what they're not entitled to. I know there's red top popular tabloids have very negative views of welfare rights and welfare benefits. But it's a measure of a civilised society, making sure everybody who's sick, disabled, elderly, unemployed, who can't work, are getting what they're entitled to and can live. And it's increasingly, it's very difficult to. I mean, although benefits are going up today, 10.4%, fantastic, so it should. But it's still very, very difficult to function just on benefits. It's not living, it's existing, it's subsisting. Over the years I've been doing welfare benefits, when I started there were no food banks, none. Food banks, it's awful. They shouldn't exist, quite frankly, and they've been mainstreamed. People shouldn't have to beg for food, and families, but now they're there. And quite frankly, if you're not entitled, you've got to exist, and you're talking families, and that's children, although it's not children who represent in the main, although certainly do represent children with a disability living allowance. But they're the ones who are affected by it. The parents are subjected to sanctions for whatever reasons. But some of the decisions that we get at tribunal, I recall one was a homeless person. He'd been in and out of prison. There'd been huge issues to do with qualifying benefit. Very difficult to pin him down. Learning difficulties, alcoholism, drug addiction. Eventually, managed to pin him down to go through the fact finding. Luckily, I could talk to his probation officer. We got to tribunal. We won. It should never have been a tribunal. He should never have had his benefit taken off him. The net outcome for him, £26,000. Fantastic result. Luckily, he had a relative who had his bank card. I'm pleased to say. And he did actually bring which was a huge success, really. He came in and he gave a gift of a bottle of whiskey. I thought, that's fantastic. I just gave it. I don't drink alcohol, but he put it to one side. But the fact that he was giving me it, not drinking it himself, fantastic. But it's about just making sure that everybody's getting what they're entitled to. And yeah, from a personal point of view, there's immense satisfaction winning the tribunal and making sure that people are treated the way they should be. That's basically all I wanted to talk about. If there's any questions, that's fine. Anything? There's leaflets outside. If you want to contact us direct, that's fine. But again, we are a specialist advocacy service that we give, welfare rights representation service. If it's about claiming benefits in the first place, Citizens Advice Bureau, Equal Lives, Age UK, Age Norfolk, Mancross Advice Project. These are any number of advice agencies and support agencies. But it's making sure that you claim them in the first place. Thank you. Any questions?
I was just going to ask one. If you won by MR, the next time when you do again, is it taken? Do they look that you've got a mandatory reconsideration the previous time, or do they sort of class you as a level? Because I know if you've won through tribunal, when your time ends, they look at it as you won through tribunal, that's it. Start again. Is it the same for MRs?
With the mandatory reconsideration, just like a tribunal, the tribunal decisions, once they're set in stone, that's unless you were to get that set aside because of the issues and problems to do with that. But with the mandatory reconsideration, whoever made that decision, the decision maker in the DWP, a subsequent decision maker wouldn't be held to that. And if they thought there was an error, they'd made a mistake, they gave a higher award than they thought they should do, they can go back prior to that mandatory reconsideration and get that overturned. The overpayments that come through, I mean, it used to be the case that if you could show that it was an official error, you could get an overpayment written off. Now, of course, it's the law and the regulations have changed. It doesn't matter whether it's your mistake, the DWP's mistake, your partner's mistake, your neighbour's or your dog's. If it's an overpayment, they want the money back. They come back for it. But having said that, you can ask for it to be written off, a waiver. I'm not against that. Very rare does it happen. I had one client who this is how quirky it gets really, who was on DLA, this was before personal independence payments, and was saving up for a car. She was already getting maximum, the highest rate of mobility, and could have got a car, but didn't realise that for whatever reason, and was saving it up. And of course she received a multiplicity of decision letters from the DWP, and it lists down, this is how much the law says you need to live on, and the list will say, your DLA does not affect your benefit. And you've had multiple letters saying, your DLA does not affect your benefit. But of course, if you save your benefit up, your DLA, it then transmogrifies into capital. So then she was at an overpayment. It's over £12,000. It's a lot of money when you're on benefit, a lot of money for everyone, quite frankly. And I did ask for it to be written off because of the mental health issues. They said no. It just didn't seem right, quite frankly. I mean, she was taking it, the paperwork was there, and it's saying quite clearly, your DLA does not affect your benefit. So I asked for it again, and they said no, again. I'm sorry, I'm very doubting Thomas, that it's just not right. It's about being fair. It just didn't seem fair. So a third time, went back again, and at this stage the client did attempt suicide. He was so worried about the overpayment. And it came back, it was written off after the third time of asking. But it came to that the DWP couldn't say yes. Anything over £10,000, it'd have to go to the Treasury. I thought, oh, crikey. The DWP are dealing in billions. I think it's something like over 200 billion a year. It's the amount of the budget of the DWP is up there with Walmart, quite frankly. But they weren't allowed to say yes to a £12,000 overpayment, but it worked. It is about being persistent, getting a representative, not having to deal with it yourself. And again, it's the words you use in terms of the disabling effects. Whatever the condition is, you've got to get on with life. So it's about being as positive as possible. And I have to say, the system, in inverted commas, will tend to hold your coping strategies against you. They'll say, well, I might ask, well, do you go into town shopping? They'll say, oh, yeah, I do, but I like to have someone with me. As soon as you use the L word, like, a line will go through that. Even though you're being as positive as possible, it needs to be, no, I cannot go into town unless I have someone with me. So there's no casual conversation. For these words, just at the initial claim stage, making sure you get the wording right in how you claim the benefit. So again, getting help and assistance, citizens' advice, equal lives, is very important. Again, the best tribunals, the best appeals are those you can avoid. Get the right decision in the first place. It'd be nice. I shouldn't have a job, quite frankly. Well, I'm effectively the DWP's complaints department. They don't pay us anything, but it's immensely satisfying when we win. It's right. Righting a wrong, and there's so many wrongs. And of course, there's lots of people who don't come and see us, and they should. And although we're a small advice agency doing representation, there should be a queue of people going down the street screaming blue murder because their rights are being infringed. And so, yep.
So one of our young people I support, he is 17 and a half, and he was living at home, and he got enhanced daily living of PIP and standard mobility. He had to be moved from home and is now in a supported living accommodation, and his PIP stopped because he's being cared for. I think that is so wrong because he still needs the money to go out and do things and enhance his life, isn't it? So I just want to know if that's something I can come to you guys to try and fight for, because he's now not getting any money.
Yes. Oh. In any event, yes, come to ask for further advice. If you were to go into hospital, into a care home, more than 28 days, then yeah, they'll take it away. But then if it's supported living, if he's living in a place of his own, and it's just there's a warden there, and someone comes in, it's on definitions and how you look at it. The law is very specific, and it could be, and again, when we go to appeal, and we go to the upper tribunal, and then it can go further than that. It can go to the Court of Appeal, and they used to go up to the House of Lords. There was one argument I was putting for human rights argument, and I got a letter back from the DWP, and it went up to their specialist officers in Leeds, and it was from their lawyer, and it said, well, this chap's argument is absolutely rubbish. It doesn't hold any water. Unlike the one from Liverpool CAB, I thought, ah, fantastic. So, of course, I got in touch with Liverpool CAB straight away. And I got to talk to the person that went to the upper tribunal, or was commissioners as was then. And she'd gone along in person, and it's a different kind of hearing in person. And the DWP were there. They had a specialist solicitor for human rights. And then they had a specialist solicitor to do with European legislation, and then they had a barrister against the manager of the Citizens Advice Bureau in Liverpool, and she won. Fantastic. It's about, they bring them out and then start arguing over the definition of what is nighttime. Nighttime's different people. Some people go to bed at 10, some people go to bed at 11, some people don't go to bed at all. You start wondering why you'd start paying someone £750 an hour to start arguing over what does attention mean, what does support mean. But it's very specific. These are arguments, again. So yes, get further evidence, get further advice on it. Don't just automatically accept the decision. No, so seek further advice. And I mean, also, I can't guarantee whether it is or it isn't. It depends on how he's living or what the setup is.